called the complainant and stated that he was going to kill her and then showed up at her.
It's Jonathan Johnson. Okay. Oh, I think I remember this. Are you here for that, Sebastian? Johnson?
I believe it's a sign on
Is this the one that we had spoken about? Come up, Mr. Johnson. Hey, can you have that you're going? This guy was working and he put NA on her. I don't believe that. Can you have him refill it out? Please. And if he wants time, send him on his way.
I'll be with you. It's one out of lunch.
Mr. Johnson, you were charged. Shh. You were charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
And judges, you know the details of
Shh.
this case are quiet.
Say, just read it.
Officer reviewed a police report from February 4th, 2025, after the officer spoke with the complainant. The complainant stated the defendant, her ex-boyfriend, called the complainant and stated that he was going to kill her and then showed up at her job. The defendant was approached by security and fled the scene prior to contacting the complainant. On February 24th, 2025, the defiant officer called the complainant. The complainant stated that on February 7th, 2025, she told the defendant via phone call to stop harassing her, and the defendant told her he did not give a fuck. On February 12th, 2025, the complainant received an email that stated, "Skip, bitch, I just love you." The defendant also sent a 20-second pornography video. The video showed a female laying on her stomach, nude, and the video zoomed in on the female's with fingers being used to spread the female's buttocks to expose the inside of her. The complainant recognized the hand and the fingers in the video to belong to the defendant and recognized the room. The complainant stated the defendant had previously emailed her on March 16, 2024 from the same email, sending a picture of himself at work. On February 18, 2025, the defendant emailed the complainant 6 times. On February 23, 2025, the defendant emailed the complainant 9 times. On February 24, 2025, the defendant emailed the complainant once. The complainant changed her phone number on February 22, 2025, because she kept getting phone calls from unknown numbers, and when she would answer, the call would hang up. The officer texted a photo of the defendant from his Texas driver's license, and the complainant identified the defendant.
The pornography video that was sent.
We don't know the ID of the female in the video.
So yeah, I think it would probably take some more investigating to figure out if you actually leave that female, and obviously we can't speak to her tenant about it. I don't know if it's really recognized her. But that is
She would say whether she recognized it was her.
The judge's reaction says a lot here. He's hinting that the alleged conduct may involve offenses beyond simple harassment, which could require additional investigation before any new charges are filed. Remember, these allegations still have to be proven in court, but the details are serious enough that the courtroom mood changes instantly. Did you notice how everyone suddenly became much more cautious?
I would imagine that there's a whole host.
that's a felony.
Yeah. We haven't spoken to her directly yet, Your Honor.
It's just because it's been informed by the
Mr. Johnson, I'm going to find if there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to order you not to have any contact with the complaining witness. I'm going to put a GPS monitor on you so I know where you are at all times. If I find that you go anywhere near this person, if I find that you try to have any communication with this person through any means, I don't care what it is, if it's Snapchat, if it's Facebook, social media, smoke signals, whatever it is, I will put you in jail. I'm going to do everything in my power to protect my community at all costs. I don't care who you are. Do you understand?
Yes, sir.
I'm now entering into what's called a Matchett's Order for Emergency Protection. This is a court order that identifies Ms. Turner as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.07 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order, the state can and will probably file a violation of protective order. It's one of the worst cases that you can pick up. Do you understand?
Yes, sir.
Okay, we need to talk about bond.
Your Honor, the defendant works for Enterprise. He's an IT specialist. He's been working there for over 5 years, and he's got ties here. He's been living in Houston for over 5 years, and he has child support for 3 children that he takes care of on the weekends. They're with the baby mom on the weekdays, but he does work. He is working, and so we would ask that he needs no threat. He's not shown any threat previously, and it's that strong ties. So we were requesting a bond of $1,500. We have the bondsman here today.
I would be unopposed to a bond of $1,500 if he were to have a GPS monitor with an exclusion code.
I'm
So-
looking for it.
Yeah, so I'm unopposed to that as long as he has the exclusion code.
Bond will be set at the 1,500 then. You will get no more warnings, Mr. Johnson.
Here's an important legal takeaway. The defense emphasized the defendant's job, family responsibilities, and community ties to argue for a lower bond. Those factors can influence release decisions, but they don't erase the allegations. The court is trying to balance 2 priorities at once: protecting the community while respecting the defendant's right to remain free until proven guilty. Do you think the judge struck the right balance with a $1,500 bond and GPS monitoring?
You're in the free world now. Act accordingly. If I find that you do anything, it's not going to go well. Do you understand?
Yes, sir.
Okay. All right. So you have a bonding company here now? He'll have to meet with the child first for all the bond conditions. Then after that, we can release him to the bonding company.
If he's ever objected.
Yeah, for sure. Okay. All right. Thanks, Joe.
Judge, the bond was set at what amount?
1,500. Good morning, Ms. Hickman. Ma'am, you charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 22nd, 2024, at approximately 1 a.m., the officer observed a vehicle traveling on the wrong side of the road in the flag of their patrol vehicle on Prairie in Maine. The defendant's vehicle ended up on top of the curb about 10 feet in front of the patrol vehicle, and a traffic stop was initiated. The officer observed a strong odor of alcohol emitting from the defendant, disorientation, and slurred speech. The officer asked the defendant to step out of the vehicle, and the defendant stumbled out. The defendant admitted to consuming alcohol and stated that she was coming home from a club. SFSTs were conducted. It was a 6 out of 6 on the HGN, but the defendant refused to walk and turn in one-leg stand. The defendant was arrested and was uncooperative during questioning the reasons for her arrest and refusing to provide her name and date of birth. The defendant had 2 intoxicated passengers in the back seat, one of which vomited on scene. The defendant asked to remove her shoes while being escorted to the patrol vehicle, and when they arrived at the jail, the defendant refused to exit the patrol.
Now we shift to a completely different case, but notice the similarities in procedure. The officer documents every observation, from driving behavior to physical signs of impairment and the refusal to provide a specimen. In DUI investigations, those observations often become some of the most important pieces of evidence. Which detail do you think carries the most weight in court? The driving itself, the field sobriety tests, or the refusal to cooperate?
The vehicle without her shoes and insisted on being carried. The DIC was read. The defendant was argumentative and refused to provide a specimen. The blood warrant was signed and executed, and she was identified by her Texas driver's license.
Any prior DWIs?
No priors, Your Honor.
You did run a license?
Yes, she does have a valid license.
Okay. Ms. Hickman, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming it, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay, we're going to give you time. I'll have you go to Victoria, sign and reset. You'll get me.
Two very different cases, but the same courtroom lesson. Bond hearings aren't about deciding guilt or innocence. They're about determining whether there's enough evidence to move the case forward and what conditions are necessary before trial. One defendant leaves with strict protective conditions, the other with sobriety requirements and random testing. Which ruling stood out to you the most? And do you think the judge handled both situations fairly?